Welcome back to the Constitutional Clarion. More and more often these days I see claims that local government is constitutionally invalid because it's not mentioned in the Constitution and was rejected at referendums. It's also claimed that local government has no power to impose council rates, although curiously people don't tend to claim that it has no power to provide the services that are actually paid for by those rates, such as roads and footpaths and gutters and garbage removal. Ordinarily, the claims that local government is unconstitutional are just aggressively asserted on social media as a matter of fact. But I received an email the other day from someone who genuinely wanted to know whether it was true. She was worried that it was causing friends to refuse to pay rates, and she was aware of local councillors who were being threatened because of these claims. Now, points to those of you who genuinely want to learn rather than just accepting bald statements from random people on the internet. So in this video, I'm going to go step by step through the law and history to explain the legal basis of local government in Australia. Let's start with the history. Some of the anti-local government claims assert that local government was created after federation, or indeed after it had been rejected in referendums by the people in defiance of their will. In fact, local government was established in the 19th century and therefore preceded federation. In New South Wales, for example, after a couple of failed attempts, local government started with the enactment of the Municipalities Act 1858, although local government in the City of Sydney was actually established earlier, in 1842. Indeed, the Sydney City Incorporation Act of 1842 took civic duty so seriously that people had no right to refuse nomination to election to a local council, and were also fined if they refused to accept office once they were elected. One fellow who was nominated against his will campaigned against himself, claiming that he was excessively indolent and exceedingly bad-tempered. He later served as Mayor of Sydney. Enough said. For anyone who's actually interested in the history of local government, there's actually this 2-volume set on the origins of local government in New South Wales. Worth a read. Okay, so it's also worthwhile pointing out that the very first democratic government election in Australia was for the Adelaide City Council in 1840. Local government didn't become widespread in Australia until about the 1860s and 1870s. Its franchise was a property-based one because council services directly benefit property owners. When we come to the drafting of the Commonwealth Constitution, its framers were very well aware of the existence of local government as established by legislation enacted in each of the colonies. One of the aims of federation was to confer power on the Commonwealth Parliament to deal with national matters such as defence, immigration and external affairs, as well as matters that needed to be dealt with uniformly across Australia or which involved matters that cross state borders. Local government was clearly a local matter, not a national one, and it was therefore left to the states. Sir Samuel Griffith, one of the framers of the Constitution, said this expressly in a speech to the Constitutional Convention on the 31st of March 1891 when he was explaining the scheme of the draft Constitution. He pointed out that lots of things were left to the states, such as education, criminal law, land registration and, critically for our purposes, municipal institutions. He also rejected the idea that these things should be specified in the Commonwealth Constitution. He thought that the Canadian system, where you give a list of different powers to each level of government, was, as he called it, unscientific because it would be impossible to enumerate all powers in these lists. Instead, he opted for the American system of giving the federal level of government a list of powers and leaving the states with what's called plenary power. That means full power to enact any law that they want on absolutely anything, as long as the subject matter hasn't been taken away from them by the Constitution. Now, if the state law is inconsistent with valid Commonwealth law, then the Commonwealth law prevails. But other than that, the states have full legislative power to deal with everything, including the power to establish and maintain systems of local government and to confer upon local government the ability to impose rates. This system of government was enacted by the Commonwealth Constitution. There's no need to mention local government in the Constitution because it falls within the plenary powers of the states, which are conferred by the state constitutions and were recognised and continued in existence by sections 106 to 108 of the Commonwealth Constitution. People who argue that local government is unconstitutional often point to page 936 of a book by Quick and Garran. Okay, now they claim that this is the Constitution. Right? It's not the Constitution. The Constitution is much thinner, as I've shown you before. This is a book about the Constitution. It explains the Constitution's history and it explains what is intended by the various provisions. If the people who refer to Quick and Garran actually read the pages from 933 to 936, they would see that it's explained there what I have just explained to you. And that is that the Commonwealth Parliament does have powers, some exclusive powers that have been withdrawn from the states, as well as concurrent powers, which both the Commonwealth and the states can legislate about, and if there is a conflict, then the Commonwealth law prevails. Then at pages 935 to 6, Quick and Garran set out a list of other powers that are left to the states that are beyond those that have been allocated to the Commonwealth. Okay, so let me just show you. So on page 936, in that particular list, they list municipal institutions and local government. Okay, this is expressly listed here as something that has been left to the states to deal with. It does not fall within Commonwealth power. Another source of confusion concerns taxes. People claim that only the Commonwealth Parliament can impose a tax. Now that's just not true. The Commonwealth's legislative power to impose a tax is not an exclusive power. It's a power that's in the list of concurrent powers in section 51 of the Constitution. So that's a power that both the Commonwealth and the states can exercise. States have plenary legislative power to impose taxes unless the Commonwealth Constitution takes that power away from them, which it has in relation to a certain type of tax, and that's called an excise, which is a particular type of tax on goods. Other than that, states have full plenary power to legislate, to impose taxes, and to confer upon local government the power to impose rates in relation to land. So what about those claims about referendums? What's all that about? Didn't we vote in referendums to oppose having local government? Well, the answer is no. There were two referendums held in 1974 and 1988, and an abortive one that was meant to be held in 2013 but was dropped. As always, it's important to look at what they actually said. The 1974 one would have done two things. It would have amended section 51 of the Constitution to give the Commonwealth Parliament power to make laws with respect to the borrowing of money by the Commonwealth for local government bodies. It would also have added section 96 capital A, which would say, the Parliament may grant financial assistance to any local government body on such terms and conditions as the Parliament thinks fit. That's referring there to the Commonwealth Parliament. Okay. What it was about was the Commonwealth trying to bypass the states to give funding directly to local government. It was rejected at the referendum, leaving Commonwealth funding to local government to go through the states, as it previously had. The referendum had nothing whatsoever to do with whether local government should exist or not. If you read the no case that was provided to voters for that referendum, the complaint was that the proposed amendment would put power to control your council into Canberra's hands, and that it offers a money bribe without making clear the terms and conditions imposed upon it. It was also described as an underhand attempt to put Canberra's bureaucratic fingers into every one of Australia's council chambers. The no case was certainly not advocating the end of local government. It was trying to keep local government as bodies controlled by the states, not the Commonwealth. Well, what about the 1988 referendum? It proposed the insertion of a new section 119(a) in the Constitution. It would have said the following: each state shall provide for the establishment and continuance of a system of local government with local government bodies elected in accordance with the laws of the states and empowered to administer and to make bylaws for their respective areas in accordance with the laws of the state. This would have preserved the existing position that local councils are established by states and have powers to make bylaws conferred upon them by the states. But it would have prevented a state from abolishing local government or providing for local government bodies to be appointed rather than elected. It was intended to restrict states in how they deal with local government, and in particular to prevent them from replacing corrupt councils with administrators rather than a newly elected council. Now, the referendum again failed, with the people voting against these constitutional protections for local government and to leave local government as it is, being established and controlled by state legislation only. Again, it had nothing to do with abolishing local government or making it unconstitutional. Both the yes and the no cases in the referendum supported and accepted the ongoing existence of local government. In 2013, the Commonwealth Parliament passed a bill for a referendum on local government. It was later dropped before the referendum was held after Kevin Rudd replaced Julia Gillard as Prime Minister and changed the proposed election date to avoid having to hold the referendum, which he presumably thought was going to lose. Now, what would that referendum have done? Well, it really was going back to the 1974 proposal. It would have altered Section 96 of the Constitution so that the Commonwealth Parliament could grant financial assistance directly to local government on such terms and conditions as the Parliament thinks fit. Again, it had nothing to do with the abolition of local government. Local government continues to exist under state laws enacted under the plenary legislative power of the states. The powers of local government bodies to make bylaws and impose rates are set out in the relevant local government legislation. If the local government body obeys those rules, then its imposition of rates is valid. For example, in New South Wales, you can look at Chapter 15 of the Local Government Act 1993 to see what the rules are. Can't say I actually recommend this because it is very long and complicated, but it is there if you want to read it. It's not just me, by the way, saying that local government is constitutionally valid. Every time someone has gone to court arguing that local government is constitutionally invalid, they have lost. Now, this is because, as I've explained, the argument that local government is constitutionally invalid is incontrovertibly wrong. For example, in paragraph 47 of a 2023 case called Turnbull and the Clarence Valley Council, the New South Wales Supreme Court recorded that the plaintiff contended that local councils, quote, are unconstitutional by reason of the failure of the constitutional referendum, which would have included a reference in the Australian Constitution to local government. The judge rejected that argument, noting that it had also previously been dismissed by the Chief Justice Spiegelman, in an earlier case where he said this, quote, "There is no logic in this. Local governments are created by state legislation under the respective state constitutions. The absence of any reference to local government in the Australian Constitution is just irrelevant," unquote. The judge also noted that the enactment of the Local Government Act has been found to fall within the plenary power given to state parliament by the New South Wales Constitution. There have been a slew of these cases in other states, especially in Western Australia. When in one of these cases, special leave was sought to the High Court of Australia, Justice Gummow of the High Court said that the local court had rejected the argument that Local Government Act was unconstitutional. The District Court had dismissed the appeal. The Court of Appeal of the Supreme Court of Western Australia had dismissed a further appeal as, quote, "entirely lacking in legal merit," unquote. And then Justice Gummow said, on behalf of the court, "We agree." Special leave was refused. Even though the argument is, quote, "entirely lacking in merit," unquote, people keep running it in court, wasting the time of the court and taxpayers' money in paying for those proceedings. They lose and frequently have costs orders made against them. No one wins from this except the people who actually charge for disseminating this wrong advice. So what does all this tell us? Well, first it tells us that those people who flood social media with assertions that the Australian people voted in referendums against the existence of local government and that it's unconstitutional are talking complete codswallop. Anyone who looked at the terms of those proposed amendments would know that. So either they are directly lying to you, or they are too lazy or reckless to bother to do even the most basic primary research to look at the constitutional questions that were actually voted on in those referendums. Do not believe these people or anything else they say about the Constitution either. Now, my final point here is a serious one. There's an important national security element to this as well. Foreign actors who want to destroy Australia's democratic system are increasingly using social media to spread claims that cause division in the community, distrust in government and elections, and rejection of the rule of law. Now, they will tell you that the Australian Electoral Commission is corrupt. They will tell you that elections are rigged and stolen. They will claim that local government is constitutionally invalid. They will instruct you not to pay your taxes and not to obey the laws because they're all invalid. This is foreign interference 101. It's how you undermine democracy. Now, you may believe that the website that's telling you these things comes from a true blue Aussie patriot. As often as not, however, it actually comes from a disinformation factory from outside Australia and is routed through a number of countries before it gets here. And even if it does come from a person who is utterly genuine and believes it to be true, they can still be unwittingly doing the work of foreign agents spreading disinformation, because those agents rely on the fact that Australians are not properly educated about how our system of government works and are therefore vulnerable to their lies. So before you spread such material to others, think long and hard. If it's undermining trust in the system of government, be suspicious and ask who benefits from that. Consult people with genuine legal expertise who can explain the facts. Don't be an agent for foreign interference. Don't undermine your own country by spreading patently false claims. This isn't just silly stuff. It's corrosive of public trust, and therefore it's potentially dangerous. On that more sombre note, thank you again for watching the Constitutional Clarion, and as always, I look forward to seeing you next time. Goodbye.